After the euphoria of that last speech, you might have forgotten, so I'll just quickly recap. She qualified in London, worked in Malaysia. She's been a barrister of the High Court and the Federal Court of Australia, is now a lecturer in law at Flinders University. So very well qualified to talk to us, as everyone has been. She's collaborated with Bob Moles on a number of law-changing publications, which one of them will tell us about. Her speciality is something called cognitive bias, which is a simple journo I think I understand as being the way in which coppers regard securing a conviction sometimes much more important than solving a complex murder case in this case. These are and other questions I'm sure Bibi will answer. Bibi, I make way for you now.
Thank you, Charles. My talk today, as Charles said, will focus on cognitive bias in criminal cases. Now, in considering the issue of cognitive bias in law, we reflect for a moment on some aspects of our history. Whilst in Edinburgh recently, we visited Edinburgh Castle and noticed a small plaque affixed to the wall near the entrance to the forecourt. It stated that it marked the place where hundreds of women had in times past been strangled and burned for being witches. The collective thought that those women possessed mysterious powers which presented such a threat to the wider community that they should be strangled and burned as a form of public entertainment is, of course, horrendous. But as I reflected upon that issue, I wondered how far we have really come since those gruesome days. I remembered the story which a former English judge had told about some of the marvelous contributions he had made to the development of law. One was a case involving what he called the good captain. We have written about this case in an article for the Flinders Journal of Law Reform in 1997. We reported that Lord Denning, who had been one of UK's leading judges for a great many years, was giving a summary of his major achievements. He recalled that as a trial judge, he had to deal with a case which involved a person that he described as an awfully good man. This man was a captain in the army and had been off on a 2-week course. When he returned home, he said that his wife had nagged him until he could stand it no more. So, as Lord Denning said, he upped and out with his revolver and shot her dead, adding as an afterthought, 6 months pregnant as she was. Denning then explained that he had summed up to the jury quite correctly. He told the jury quite clearly that words alone could not constitute provocation so as to reduce the conviction from murder to manslaughter. It was not suggested that the man's wife had used anything other than words. However, Denning then went on to say that he was not sure whether it was the words he actually used or, more importantly, the way in which he used them. But at all events, this apparently sensible jury came back with a verdict of guilty of manslaughter only. As Denning said with a wiry smile, what was I to do? I could see the mitigating circumstances. At this point, we can only ask incredulously, what could there possibly be? Denning then went on to say that because of those mitigating circumstances, he sentenced the good captain to 18 months imprisonment, adding, of course, that he wouldn't even have to serve that because he was on remand during that period and had done his 18 months. He finished by adding that although they ought not to have done it, the people in the public gallery stood up and cheered. The man, as an army captain, had killed his defenseless wife and an unborn child because she had upset him by trying to express her concerns to him. In this case, Lord Denning had manipulated the law and the jury to ensure that the perpetrator of this shocking crime would avoid any significant punishment. And the people in the public gallery stood and cheered. I think they would have been members of his family rather than her family. It made me think of the crowds in the witch burning all those years ago. This appalling act of domestic violence brought to my mind the way in which the judiciary in the UK, some 40 years later, had responded to groundbreaking legislation to protect victims of such violence. The appeal judges virtually stripped it of any significant effect. It was around 1976 when the Domestic Violence and Matrimonial Proceedings Act 1976 was passed. And it was as a result of the interaction between women's rights and the rights of property owners. There had been for many years growing concerns about the scourge of domestic violence there, just as it is here today. Eventually, those who had campaigned long and hard for greater protection for women won through. So there was an amendment to the legislation to enable victims of domestic violence, including children, to remain in matrimonial home. Up until then, such victims had usually been required to flee the home to seek safety at some homeless refuge or women's center. And that had become a matter of grave concern. This new statutory provision provided that where domestic violence had occurred, the perpetrator could be issued with an order by the court to leave the home. When one of the first cases came to the appeal court, the judges gave a surprising twist to the interpretation of that legislation. Lawyers acting for the man who had been served with that order had complained that if he was an owner or joint owner, a tenant or joint tenant of the home in which he had lived, then the effect of an exclusion order would interfere with the exercise of his property rights. He has got the right to be there. The appeal judges noted that the legislation made no reference to the issue of property rights in that provision. The judges therefore said they were entitled to draw an inference that if the Act had not referred to the issue of property rights, then there was a clear indication that it was not meant to apply to people who had property rights in the matrimonial home. So they concluded if the person committing an act of domestic violence is an owner or a joint owner or a tenant or joint tenant of the matrimonial home, the Act will not apply to them. The net result was that it's difficult to imagine what sort of person might come within the provision of that legislation. Any person who was not an owner or joint owner or tenant or joint tenant would in effect become a trespasser once their invitation to remain is withdrawn. The powers under the Act would not be necessarily applicable to such people. There was of course an outcry, as you can imagine, with such an absurd interpretation of this major piece of social legislation. The primary and obvious intention was clearly to protect the rights of women and children who were subjected to domestic violence. 2 consecutive divisions of the appeal court had affirmed the virtual abrogation of that law as being correct. Ironically, it was the former Justice Denning, now who was the head of the appeal court as Lord Denning, who had to do some hard work to revise the interpretation of the law as part of a damage limitation exercise. And he did so by overriding the normal procedural rules governing the role of appeal court. But that's a story for another day. So Denning did do a lot of good in stepping in. Now, the lesson to be learned from this event is that even in the mid 1970s, the rights of women and children to be free from the scourge of domestic violence was not a high priority as far as the judges were concerned in protecting the property rights of those who were committing appalling acts of violence. Now, another interesting example of judges' ability to interpret the facts and law to fit in with their view of the power of women, and in this context I'll be talking about in the context of property rights, can be seen in a South Australian case of Lewis Dipros and Mary Louth. So if you'd indulge me a little, this is a case I often enjoy talking to students about when I'm talking to them about gender perspective in commercial law. Now, the idea that women's rights to be free from violence can be abrogated with judicial approval when they conflict with the financial interest of others with whom they are involved is no doubt allied to the view that women are scheming, manipulative, they exercise inappropriate powers or act in dangerous ways without real proof of them doing so. In this case, Lewis Dipros was a man with a mission. He had met Mary Louth socially at a party in Tasmania and became captivated by her. So much so that as a solicitor, he moved his practice to Adelaide after Mary had moved there to be with some other members of her family who were able to assist her socially. She said to Lewis that she wanted to be a friend, but not an intimate partner. She had been raped when she was younger in circumstances where she thought she might be killed. So she was naturally wary of men, generally, but certainly of sexual intimacy in this particular case. Lewis pursued her, taking her to fine restaurants, bought her French champagne, and even took her for trips in an aeroplane that he owned. When her accommodation became insecure, he offered her a place at a property he owned. She declined the offer, thinking that if she were his tenant, he might use that inappropriately to his advantage. Eventually, Lewis offered to transfer a property bought by buying it and transferring it into her name, and said there are no strings attached. Initially, Mary refused, saying that she did not come from the sort of people who gave homes to each other. Lewis persisted, and eventually she agreed. He conveyed the property into her name, and subsequently, to cut the story short, a few years later, Mary's worst fears were realized. Lewis subsequently claimed to be in difficulties with his own accommodation. He persuaded her to let him come and stay with her for a short while. Whilst there, he tried to achieve his objectives, and when Mary refused, he left angrily and told her he would get his house back. He sued Mary, claiming that she had always agreed to return the house to him, upon his explicit request to do so, and therefore she only held the property subject to what in law we call a trust. So he was the rightful owner, she was only holding it in trust for him. The judge, who was the Chief Justice in the South Australian Supreme Court, could clearly relate to Lewis, the solicitor, more readily than someone like Mary, who was a single mother on state pension. He clearly thought Mary was a scheming and manipulative person. He described her as niggardly in not offering to share her accommodation with Lewis more readily, after all he had done for her. He said he didn't believe her when she said she thought Lewis was well off after treating her so well. Lewis, on the other hand, was seen by the judge to be a romantic person who had an unrequited love for Mary. The judge said he wrote tender, sentimental, passionate, these are his words, poems to her, motivated by his unrequited love. He even had them bound in leather covers, so they were all completely unsolicited. He was sending them to her. Others might have described the poems as vulgar, with strong sexual and sometimes explicit connotations. Yet he was seen by the judge as a wistful lover and not one, as others might have suggested, motivated by his lust for Mary. The judge took the view that his love for Mary made him emotionally dependent upon her and had exposed him to her influence. The judge said that in this state, Lewis was unable to determine what was in his best interest. And ultimately, as the judge says, he lost his reason. Now, despite being a solicitor in practice throughout that period of time, the judge took the view that Mary's influence upon him had the effect of depriving him of an independent and voluntary will. Eventually, the judge explained it was her niggardliness in refusing to share her accommodation with him that caused the scales to fall off his eyes. So this was the language he was using, very much the Mills and Boons language. And then right reason returned. He wanted his house back. During the time that Lewis had lost both his will and his reason, Mary had been, according to the judge, calculating, scheming, and manipulative, while Lewis was utterly vulnerable to her behavior. The judge said Mary had tailored her evidence to advance her case. He said, I don't believe that Mary thought Lewis was well off, despite the lavish meals and aeroplane rides. Yet, when it came to the main issue in the case, the judge said, actually, on this issue, Lewis is untruthful. Lewis had said that Mary had agreed to transfer the house back to him on the clear understanding that it was going to be held in trust for him. The judge said, however, if you look at his will and you look at other business arrangements he had made, he makes no mention of that house, and therefore it couldn't have been that intention. So on the main issue on which the case was pleaded, which was that there was a trust in place, the judge says, now, I don't agree with Lewis. I don't find him truthful on that. And he does that not by saying, I believe Mary's evidence. What he says is, I don't believe Lewis on this issue because his other evidence is inconsistent with this claim. As the judge goes on to say, I place little reliance upon the evidence of the defendant, namely Mary Louth, where it serves her own interest. But the other evidence in the case so strongly confirms that the plaintiff made a gift of the house to the defendant that I have no hesitation in holding that it was a gift. The presumption of trust arising from the provision of the purchase money by the plaintiff is therefore rebutted. So in other words, there's no evidence of trust. Now, the fact that Lewis, a solicitor and an officer of the court, had given false evidence on oath to bolster his claim was not subject to any robust comments by the judge. So the judge was never critical of Lewis for telling lies in court. Lewis's evidence was only rejected when it contradicted his own previous evidence. So on all other points, the evidence of the otherwise proved to be untruthful Lewis was preferred to that of the scheming Mary. Lewis's lawyers had only included an alternative claim based on emotional dependence as an afterthought. So their principal argument was trust. So this was just an afterthought in case everything else fails. But for the judge, that was enough to turn the tables and to find against Mary. The destitute and struggling Mary, it seemed, had mysterious powers which overwhelmed the mind and reasoning capacity of the well-established lawyer to the extent that he didn't appreciate what he was doing when he executed the conveyance to her. Now, these manipulations by Mary, the judge found, were based upon her unexpressed desire to take advantage of helpless Lewis, whose own attempt to manipulate the legal proceedings had so spectacularly failed. Now, it's interesting, the judge talks about her unexpressed desires. So there's no evidence of that, but that's the deduction he draws. So unexpressed desires is another way of referring to the fact that there was no evidence upon which to base the judge's findings. We are told judges make their findings in trials based on facts. The judge, majority of the appeal judges, and again, majority of the High Court judges all agreed that this terrible wrong to Lewis had to be corrected, and the house was then returned to him. I must say at this stage, there's a wonderful dissenting judgment in the High Court by one of the judges, which is well worth reading. He recognizes that Mary's voice was never heard by the trial judge. Now, shortly after this sad outcome for Mary, we were told anecdotally by a local lawyer in Adelaide that Lewis had left Adelaide for France, where he had apparently inherited a chateau for his future comfort. This case remains a leading case in the law of unconscionability in contract law, where emotional dependence gives rise to special disability so as to undermine the integrity of the transaction. It was interesting to see that even in relatively recent times, women were still being portrayed in the law as scheming, as manipulative, and able to bend even professional men to their will. The image of women's power as cold, distant, and dangerous has obviously extended in recent years into the area of their capacity to inflict harm upon their own children, and the willingness of the legal system to accept this portrayal of them as dangerous. In Canada, we were invited to make a submission to the Canadian Gouge Commission of Inquiry, which was investigating the work of Dr. Charles Smith, a pediatric pathologist whose work had been called into question. Smith was largely self-taught, but had risen to a leading position in pediatric forensic pathology in Canada. He had developed the Think 30 approach. So when mothers claimed that injuries to their babies had been caused by shortfalls or low velocity impacts, he would suggest that the more likely cause was non-accidental injuries. His work resulted in great many convictions. Not all were against women, but most were. They resulted in periods of imprisonment, broken marriages, loss of access to their other children who in some circumstances were adopted by other families. And of course, as we all know, anyone caught in the legal system is often rendered destitute by the cost of legal proceedings. Among the cases that were particularly distressing, according to the judicial report, were the of Tammy Marquardt, Leanne Theobald, Sherry Sherrod, Louise Reynolds, and Brenda Warby. Whilst Dr. Smith was under investigation, some senior legal officials suggested that all was well. The subsequent findings that they had covered up his egregious conduct led to them being dismissed and handing in their practicing certificates. Now, there was another Canadian inquiry that caused quite a scandal, and this was called the Mother Risk Hair Scandal. This program utilized hair analysis of mothers suspected of drug taking to determine if they were or had been a risk to children in their care. So a sample of their hair was analyzed for traces of illicit drug. Like Dr. Smith's scenario, the effects of the findings were devastating for the families involved, but nobody explained that the testing procedures were flawed and unreliable. When the matter first came to light, the hospital was found to have engaged in smokescreens, cover-ups, and denial, and thus exacerbated the harm that had been done. It was said that the Mother Risk scandal highlighted the risk of deferring to experts without questioning their credentials, and the laboratory's flawed hair testing methodology echoed the Charles Smith scandal with similarly devastating effects. However, the practice of using flawed procedures to obtain convictions of mostly women for putting their children at risk or even causing their death has been widespread, and notorious cases have arisen in the United Kingdom and in Australia as well as Canada. The following are just a few examples of some of the most well-known cases. In the UK, Sally Clark, who had worked as a solicitor, had been convicted of the murder of her two boys, Christopher and Harry, in 1999. When she arrived at prison after her conviction, the other prisoners shouted at her, "Die, bitch, die," because that's what they yell at people who are convicted of murdering children. She spent several years in prison, with her conviction being overturned in 2003. It transpired that the medical expert had failed to give proper attention to the potential of infection having caused the death of the children. They had known about the possibility of cerebrospinal infection at the time of the trial, but failed to disclose it, preferring to regard it as arising out of contamination. It was only discovered in the files by accident after her conviction. Her experience had been so devastating to her that 4 years after being released from prison, she died of acute alcohol poisoning. She became a chronic alcoholic. Another English case, in 2002, Angela Canning had been convicted of 2 counts of murder of her sons, Jason and Matthew. Described as a woman of good character, a loving mother, apparently free of personality disorder or psychiatric condition, she consistently denied harming any of her children. Her conviction was subsequently overturned in 2004, and the court warned against the use of experts who are overly dogmatic or who express opinions not properly based upon cogent evidence. Professor Meadows became famous for espousing the view that 1 death is sad, 2 is suspicious, 3 is murder, unless proved otherwise. Apart from reversing the onus of proof, it has a devastating effect on the thinking behind scores of cases in the UK and in Australia. As the judges in Angela Canning's case said, where there is disagreement among experts as to cause of death and where natural causes cannot be excluded, a parent should not be prosecuted unless there is additional cogent evidence of deliberate harm. And to quote them, they said, unless we are sure of the guilt of the dreadful possibility, the dreadful possibility always remains that a mother already brutally scarred by the unexplained death or deaths of a baby may find herself in prison for life for killing them when she should not be there at all. In our community and in any civilized community, that is abhorrent. And of course, Australia isn't without its own cases. The most well-known one is that's currently before an inquiry, that of Kathleen Folbig. Miss Folbig is still in prison after 19 years for causing the death of her 4 children. The experts disagreed, and there is no cogent evidence that she caused any harm to her children. Much emphasis was placed upon entries in her diary, which were ambiguous. Instead of reading them as expression of a sense of guilt from a grieving mother, they were interpreted to mean that she had been responsible for the deaths of her babies. In addition, the prosecution put a new twist to the reasoning for finding a mother guilty of murder. And it goes like this. This is the prosecutor asking question of the expert witness. Can you determine the cause of death in this case? Expert, no. Prosecutor, so you cannot exclude smothering as a possible cause of death? Expert, no, I cannot. Prosecutor, so you would say that death is consistent with smothering? Expert, yes. So when the jury subsequently told that the deaths of 4 babies are consistent with being smothered, they are likely to take the hint and the suggestion and conclude that consistent means caused by. Just as Denning used to say, was it the words I used or perhaps the way in which I used them? The experts in Miss Folbig's case were all agreed that there was no evidence that she had harmed any of her children. But 4 of them had died, one after the other, whilst in her care. An expert and prosecutor had said in the absence of any determined cause, the only inference left was deliberate harm, despite the fact that there was no evidence of it. Is this really so far away from the idea that when bad things happen, a woman, we used to call her a witch, nearby must have caused them? In Angela Cunning's case, the judges warned against drawing conclusions from the demeanor of a person when faced with an inexplicable grief. But it wasn't hard for the population to conclude that Lindy Chamberlain, without any prior history of mental problems, was able to slip away from a barbecue, kill her baby in the most gruesome circumstances, and then return to the barbecue to finish the sausages just a few minutes later. Something that even a trained assassin would find difficult. Nor was it difficult to conclude that Miss Folbig could give birth to 4 children and then kill each of them in turn without leaving any forensic evidence of having done so. Something which a trained pathologist would find to be a challenge. And now, despite overwhelming evidence of a scientific cause of death, supported by over 150 of the world's leading experts, a further and a very expensive judicial inquiry will take many more months to determine whether she should be granted leave to appeal to the appeal court. It seems that the prejudicial views of the evil that women can do can be based upon the flimsiest of evidence, or perhaps none at all. Removing that prejudice not only takes overwhelming evidence to the contrary, but also the passage of substantial amounts of time. As Stuart told us this morning, it took around a little over 3 decades for the Australian legal system to formally acknowledge that the dingo took the baby in Lindy Chamberlain's case. In the UK, they had only recently apologized to Mr. Matan's family for his wrongful execution some 70 years ago. Now, in the next session, Bob will explain how, with no cogent evidence, the prosecutors in Susan Neill-Fraser's case convinced a jury that she had exercised superhuman powers to commit another appalling crime.